What happened at the Supreme Court this morning was described as the most significant legal moment ever tied to the Second Amendment in the United States. The claim was not presented as exaggeration or political theater. The argument was that the constitutional structure surrounding firearm rights in America had been fundamentally transformed in a way that was broader, more durable, and more influential than any ruling before it. The Supreme Court of the United States released a unanimous 9-0 opinion that overturned major firearm control frameworks across all 50 states. Every justice joined the ruling. Sonia Sotomayor supported it. Elena Kagan supported it. Ketanji Brown Jackson supported it as well. The ruling stated that policies used in states such as California, New York, New Jersey, Illinois, Georgia, Maryland, Massachusetts, Hawaii, Connecticut, Delaware, and Rhode Island had crossed constitutional boundaries and could no longer stand under the Constitution. The case was identified as United States versus Henderson. According to the argument presented, anyone concerned about constitutional rights or the authority of state governments needed to understand the consequences immediately. The significance of the 9-0 decision was emphasized repeatedly. The Supreme Court contains 9 justices, and 3 of them had consistently supported firearm restrictions throughout modern Second Amendment litigation. Sotomayor, Kagan, and Jackson had repeatedly voted in favor of gun regulations in earlier landmark disputes. These justices had opposed the ruling in Heller during 2008 when the court recognized an individual right to possess firearms. They also dissented in Bruin during 2022 when New York's May issue concealed carry structure was invalidated. For years, those justices argued that governments possessed broad power to regulate firearms and that courts should defer to legislatures on public safety matters. They had become some of the strongest advocates for firearm regulation on the court. Yet this morning, all 3 joined an opinion that dismantled major portions of gun control systems in the most restrictive states in the nation. The argument claimed that when Sonia Sotomayor signs onto a ruling striking firearm laws, the event goes beyond ordinary legal development. It becomes what was described as a constitutional settlement. According to that reasoning, the issue had now been resolved at the highest judicial level in the most definitive way possible. This was not portrayed as a narrow 5-4 split, accompanied by furious dissents inviting future reversal. Instead, all 9 justices reportedly spoke with one voice. Because of that unanimity, the precedent was presented as stable and long-lasting. The ruling was described as leaving lower federal courts with little room for reinterpretation. State lawmakers seeking new restrictions would now confront a Supreme Court unified around the conclusion that prior restraints on constitutional rights could no longer continue. The importance of unanimity was framed as removing uncertainty over where constitutional boundaries now exist. Earlier Second Amendment victories had often been criticized as narrow ideological outcomes vulnerable to reversal by future courts with different memberships. According to the narrative, that possibility no longer exists. The decision allegedly established strict scrutiny as the mandatory standard for every Second Amendment restriction without exception. That principle, it was argued, had now been accepted across the court's ideological spectrum. Strict scrutiny was described as the highest constitutional test in American law. It is used in cases involving free speech, religious liberty, and racial classifications. The standard is considered extraordinarily difficult for governments to satisfy. Under strict scrutiny, the government must prove 3 separate requirements. First, the restriction must serve a compelling interest. Second, the measure must be narrowly tailored. Third, there can be no less restrictive alternative capable of achieving the same objective. The claim was that governments almost never prevail once courts apply this standard. Because of that, the argument continued. A large share of existing firearm regulations would not survive constitutional review. The court was then described as identifying 5 separate categories of firearm regulation that allegedly failed constitutional scrutiny and immediately became unenforceable across the country. The first category involved permit-to-purchase systems. These laws required individuals to obtain government authorization before buying firearms. States, including Illinois, Massachusetts, Connecticut, Maryland, New Jersey, Hawaii, and Rhode Island, were identified as having such systems. According to the description, those frameworks were now unconstitutional and could no longer be enforced. Chief Justice John Roberts was said to have written the majority opinion. The language attributed to the ruling stated that the Second Amendment protects a pre-existing right, and that governments cannot condition its exercise on permission, approval, or unnecessary delay beyond what is needed to confirm eligibility. The opinion was summarized with one central principle. Liberty is the default position. Any restriction must survive the highest level of constitutional justification. In practical terms, the argument claimed that Americans possess a constitutional right to buy firearms, and governments cannot require citizens to plead for authorization before exercising that right. Background checks verifying that a person is not prohibited from firearm ownership were described as constitutionally acceptable because verification serves a legitimate purpose. However, permit systems requiring applications, waiting periods, and official approval before exercising Second Amendment rights were characterized as unconstitutional prior restraints. The second category involved waiting periods extending beyond the time genuinely required to complete background checks. This affected many states because waiting periods had become common nationwide. California maintained a 10-day delay. Florida used a 3-day delay. Rhode Island enforced a 7-day delay. More than a dozen states reportedly used some form of waiting period. The court's reasoning was described as drawing a firm constitutional boundary. States may conduct background checks, and those checks naturally require time. Any time actually necessary to verify eligibility was described as constitutionally valid. But once the background check is finished and the purchaser has been cleared as legally eligible, the state cannot impose additional delays before the firearm is transferred. According to the narrative, extra waiting periods serve no constitutionally sufficient purpose and therefore could no longer remain in effect. The third category involved mandatory training requirements imposed before individuals could own or carry firearms. The argument stated that states cannot require citizens to complete government-approved training courses before exercising Second Amendment rights. The court's reasoning reportedly followed the same logic used throughout the broader opinion. Governments may encourage training. They may offer training opportunities. They may recommend instruction. But the right to keep and bear arms was described as a constitutional guarantee rather than a privilege dependent on state approval. The argument continued by saying that forcing citizens to complete a government-required course before exercising a constitutional protection belongs in the same category of prior restraint that would never be accepted under the First Amendment or religious liberty protections. People are not required to attend state-approved classes before speaking freely or practicing religion. According to the ruling being described, the same principle now applies to the Second Amendment. States that imposed 8-hour programs, 16-hour certification requirements, or training courses lasting multiple days as conditions for carry permits can no longer enforce those rules. The fourth category, invalidated by the court, involved good cause or proper purpose standards tied to concealed carry permits. The remaining may-issue jurisdictions included parts of California, Hawaii, Maryland, and several others. Those systems demanded that applicants prove they faced a unique self-defense threat beyond the ordinary desire of law-abiding citizens to defend themselves and their families. Applicants were expected to provide documented dangers or convince government officials that their personal situation justified exercising a right already protected by the Constitution. That standard was described as constitutionally finished. The right to carry is now presumed. A person submits an application, completes a background check, and demonstrates that they are not legally prohibited from firearm ownership. Once those conditions are met, the permit must be granted. No special justification is required. No applicant must persuade officials that they deserve the right. According to the ruling described here, the Second Amendment itself provides that authority. The fifth and final category struck down involved discretionary approval systems, where government officials possessed subjective power to deny permits based on personal judgments regarding suitability. Under the constitutional standard described in the ruling, any permit structure remaining in place must operate as a shall-issue system using objective and clearly defined requirements. If an applicant satisfies the objective standards, which include legal age, a clean background check, and absence from prohibited categories, the permit must be issued. No official anywhere in the United States may deny a permit because of a personal belief that an applicant is not the proper type of individual to exercise Second Amendment rights. The discussion then shifted to the state-by-state consequences of the ruling. The effects were described as uneven, depending on how restrictive each state's firearm laws had been before the decision. The states expected to experience the most dramatic changes included California, New York, New Jersey, Maryland, Massachusetts, Hawaii, Illinois, Connecticut, Delaware, and Rhode Island. These states operated systems combining permit-to-purchase requirements, extended waiting periods, mandatory training conditions, may-issue carry structures, and discretionary denial authority all at the same time. According to the argument, every one of those 5 categories is now unconstitutional. California's 10-day waiting period is reduced to only the time genuinely required to complete a background check, which in most situations means hours instead of days. The firearm safety certificate requirement in California, previously used as a mandatory training condition, now becomes voluntary and can no longer be required before purchase. Counties in California using may-issue policies must convert immediately to shall-issue systems. In New York, the training obligations contained in the Concealed Carry Improvement Act were described as void. Illinois, identified as perhaps the most comprehensive prior restraint system on Second Amendment rights in the country, reportedly saw its FOID card structure, 72-hour waiting period, and multiple permit conditions invalidated at the same time. New Jersey's permit-to-purchase framework was also struck down. These were described not as small changes around the edges of existing laws, but as the removal of core foundations supporting entire regulatory systems. Moderately affected states included Washington, Oregon, Colorado, Minnesota, Michigan, Pennsylvania, North Carolina, and Florida. Those states maintained some, but not all, of the restrictions invalidated by the court. Florida's waiting period is gone. States enforcing mandatory training now lose those requirements. Jurisdictions, keeping any remaining may-issue provisions or discretionary denial authority, must convert those systems into shall-issue models based on objective standards. The states least affected were constitutional carry states and shall-issue states that already imposed minimal restrictions because their laws were closer to the constitutional limits described in the ruling. Texas, Georgia, Arizona, Tennessee, and other constitutional carry states remain largely unchanged because they were described as already operating within constitutional boundaries. The discussion then turned to what comes next. The release of the ruling was not presented as the end of the conflict. Instead, it marked the beginning of a new phase. State responses were divided into 3 categories. The third category was described as the one requiring the closest attention from firearm owners living in restrictive states. The first category was immediate compliance. That response was coming from constitutional carry and shall-issue states already operating close to the constitutional standards announced by the court. Those states reportedly had little or nothing to modify and were publicly acknowledging that fact. The second category involved delayed compliance. States such as California, Washington, Oregon, and Colorado were said to recognize that they must comply, but were requesting between 30 and 90 days to revise forms, retrain employees, and update administrative systems. That delay was described as constitutionally questionable but practically expected. Firearm rights organizations were reportedly monitoring the timelines closely. The third category was resistance. That reaction was associated with New York, New Jersey, Illinois, Maryland, Massachusetts, and Hawaii. According to the discussion, these states were already searching for alternative methods to preserve restrictions while disguising them under neutral language and bureaucratic procedures. One possible workaround involved replacing permit-to-purchase systems with mandatory pre-training programs framed as educational measures instead of licensing systems. Another involved defending waiting periods as cooling-off measures justified by public safety concerns rather than administrative delay. States were also expected to convert may-issue structures into shall-issue systems, while adding 20 or 30 difficult objective requirements that would effectively recreate previous barriers using different paperwork. According to the argument, these workarounds cannot survive under the strict scrutiny standard established by the court. Organizations including the Second Amendment Foundation and the Firearms Policy Coalition were reportedly preparing legal challenges against every attempt. Strict scrutiny was described as making such replacement systems extremely difficult to defend because governments must prove not only that the regulation serves an important interest, but also that it is narrowly tailored and that no less restrictive option could accomplish the same purpose. Each workaround was expected to face immediate litigation. Under strict scrutiny, most were predicted to fail. Residents living in these states were told that if new requirements begin appearing that resemble the old restrictions already struck down, they should recognize those actions as attempts to bypass a unanimous Supreme Court ruling. The final message emphasized the importance of understanding individual rights, exercising them, and documenting any effort to block their use. The discussion then shifted toward what this decision means for future firearm legislation across the United States. According to the argument presented, the consequences for upcoming gun laws may be just as important as the impact on regulations already in place. For Congress, passing new federal firearm restrictions under a strict scrutiny standard was described as nearly impossible unless the measure is limited to a narrowly tailored universal background check framework. Bans targeting so-called assault weapons were described as unlikely to survive constitutional review because the government would have difficulty proving that prohibiting an entire class of commonly owned firearms is narrowly tailored to advance a compelling interest when those firearms are connected to only a very small percentage of crimes. Magazine capacity restrictions were also described as vulnerable under the same constitutional standard. Age-based restrictions above 18 years old were expected to face major legal challenges as well. The reasoning presented was that the right to keep and bear arms is not limited only to older adults. Under strict scrutiny, the government would need to prove that preventing citizens between 18 and 20 years old from purchasing firearms serves a compelling objective in a narrowly tailored way that cannot be achieved through less restrictive alternatives. Red flag laws, lacking strong due process protections, were also described as difficult to defend constitutionally. The argument stated that removing a constitutional right based on predictions regarding future behavior, without a proper hearing, legal representation, or full due process protections, falls into the same category of prior restraint the court allegedly ruled unconstitutional. For state legislatures, the era of experimental firearm regulation was described as finished. Every new restriction would now need to be historically grounded, narrowly tailored, and capable of surviving the most demanding constitutional review standard from the moment the legislation is drafted. States can no longer pass broad firearm control packages expecting courts to defer automatically to legislative judgment. According to the argument, courts will no longer defer in that manner because strict scrutiny places the burden entirely on the government, and that burden is extremely difficult to satisfy. For firearm owners, the constitutional question was described as settled in the strongest way possible. The legal environment surrounding challenges to existing restrictions was portrayed as becoming dramatically more favorable. Laws that survived previous challenges under weaker standards of review are now exposed to new constitutional attacks under strict scrutiny. Firearm rights organizations were expected to launch lawsuits nationwide targeting regulations, once considered legally settled. The discussion then turned toward what firearm owners should allegedly do next in response to the ruling. The first recommendation was to understand precisely what changed inside each state. Residents in California, New York, New Jersey, Illinois, Massachusetts, Maryland, Hawaii, Connecticut, Delaware, and Rhode Island were told that major restrictions had just fallen. At the same time, the practical removal of those restrictions would still take time, and efforts to replace them with alternative systems were expected. Citizens were encouraged to learn which requirements are now unenforceable and which procedures remain active while states revise their systems. The second recommendation focused on exercising newly recognized rights before states can create replacement barriers. People who delayed firearm purchases because of permit systems or waiting periods were told that the current moment presents the clearest legal landscape before states attempt to complicate the process with new regulations that appear compliant while reproducing the same obstacles in practice. Residents in former may-issue jurisdictions were encouraged to apply for carry permits immediately under the new shall-issue standards, before states potentially create additional objective requirements designed to slow applications and discourage participation. The third recommendation involved documenting any attempt by state officials to enforce restrictions invalidated by the ruling. If officials continue demanding permits already struck down, attempt to enforce waiting periods beyond the time necessary for background checks, or require training prerequisites, citizens were urged to keep detailed records. That includes preserving emails, taking written notes, recording interactions where legally permitted, filing complaints with appropriate authorities, and contacting firearm rights organizations. According to the argument, enforcing invalidated restrictions against citizens constitutes a federal civil rights violation and creates grounds for legal action. The fourth recommendation involves supporting organizations expected to challenge future workarounds. The ruling was described not as the end of litigation, but as the beginning of a new phase of legal battles. Groups including the Second Amendment Foundation and the Firearms Policy Coalition were identified as organizations preparing lawsuits against every workaround attempted by restrictive states. Those legal fights were described as expensive and long-term. The overall conclusion returned to the significance of the Supreme Court's ruling itself. According to the argument presented, the Supreme Court of the United States issued a unanimous 9-0 decision invalidating 5 major categories of firearm restrictions that existed throughout many restrictive states across America. Permit-to-purchase systems, extended waiting periods, mandatory training conditions, good cause carry standards, and discretionary denial authority were all described as unconstitutional and unenforceable nationwide. As of today, the most restrictive states were described as having lost the foundation of their firearm control structures. At the same time, strict scrutiny now allegedly applies to every Second Amendment case moving forward. That means nearly every significant firearm restriction ever enacted could now face constitutional challenges under a legal standard governments rarely survive. The constitutional question regarding whether governments may condition Second Amendment rights on prior permission and approval was described as answered unanimously by all 9 justices with a clear rejection. States most aggressive in restricting firearm rights were expected to resist through delays in replacement systems, while firearm rights organizations prepared new litigation against every workaround under the strict scrutiny framework described in the ruling. The argument concluded by stating that firearm owners who understand the ruling, recognize their rights, exercise those rights before new barriers emerge, and support ongoing litigation will be best positioned in this new legal environment. This moment was described as not the end of the conflict, but the largest victory in the history of the Second Amendment. According to the closing message, what happens next depends on whether Americans understand their constitutional rights and insist that state governments respect them. Stay informed on how states respond to these legal changes, monitor new regulations carefully, and follow ongoing court challenges as the next phase of this national legal battle unfolds. Please leave your thoughts about this content in the comments below. Thanks for watching. See you in the next one.